Okay, and we're live.
Yes, sir, we are live.
Good evening, ladies and gentlemen. Today is March the 4th. It is 7:14 p.m. This is Housing and Real Property Subcommittee. We have several bills to go through, and they will be heard in the following order: HB 93, HB 115, HB 222, HB 372, HB 390, HB 1085, and finally, HB 767 for discussion only. Let us begin with HB 93. Ben, if you could go through HB 93, Ben, and if you would like Ben to uh, share your screen as you discuss the bill, that would be greatly appreciated, Ben.
Yeah, thank you, Chair Holmes. And just asking, because we did discuss it last week, with the amendments, it maybe I can go over like it generally, but
Very, very generally, yes, because we did have this discussion last week. I just wanted to refresh person's memory. And did we move the amendments last week or did we not? I don't recall.
no, I don't.
Okay, so just very briefly, Ben, like I said, we've been through this before.
Okay, yep, thank you, Chair Holmes. It's the title of the bill is Housing and Community Development. It's Homeless Shelter Certification Program. The fiscal impact is the general fund expenditures increased by 245,000 in fiscal year 2026. Local expenditures may increase to the extent they need to be upgraded to comply with standards established by DHCD. We looked at amendments from the department while we also looked at the bill last week. The bill generally is establishing a certification system for homeless shelters in the state. It's doing that in different tiers based on the level of the shelter and the services it's providing and the duration of the services that it's providing, among other factors. It's establishing basic habitability standards, basic protections for homeless individuals. Yeah, the DHCD can do inspections of homeless shelters. So, yeah.
Thank you, Ben. And ladies and gentlemen, as we discussed, we went through this quite extensively last week, including the amendments. I'm going to make a motion to move the amendments. Is there a second?
Second.
Thank you very much. Any discussion on the amendments on HB 93? Let me scroll through, make sure I'm catching everyone. I do not see any hands. I do not see any hands. Any questions on the amendment? I don't see any hands. All in favor of the amendment signify by saying aye.
Aye.
Aye. Any opposition to the amendments? Seeing none, I move the bill as amended.
Bill's amended, sir.
Second, any discussion on HB 93 as amended, please? I'm going to scroll through, make sure I don't miss anyone. I see no hands up. All in favor of HB 93 as amended, signify by saying aye.
Aye.
Any opposition to HB 93 as amended?
Mr. Chair, I'd like to be in the know, please.
Okay, thank you appreciate that, Delegate Naraki. Anyone else in the negative on HB 93? I do appreciate it, Ryan, not Delegate Naraki. Thank you so much. That bill will receive a favorable report from the committee.
Mr. Chairman,
Yes, sir.
what was the vote on that?
That vote was,
Let me see what I can do here.
let's see here. That vote was 1, 2, 3, 4, 5, 6, 7 to 1.
Landslide.
2,
Okay.
3, 4, 5, 6. Oh, 6 to 1. I'm sorry. 6 to 1. 1, 2, 3, 4, 5, 6. Oh, 7 to 1. I'm sorry. 7 to 1. That bill was 7 to 1.
Okay.
1, 2, 3.
Yep. All right. We will now go to HB 155.
Thank you.
HB 155. Ben, if you would do us a favor, please, and go through
I'm gonna go
HB
right there.
155, please.
Thank you, Chair Holmes. I think a couple people are not on mute, just trying to. um,
Delegate, let's see, Addison.
Okay. Can,
Thank you. Great.
Okay, I feel better now.
Delegate Healy,
Yeah, I'm here.
put yourself on mute, please.
Okay, thank you, Chair Holmes. So the title of the bill for HB 155 is Housing and Community Development, Greenhouse Gas Emissions Reductions, Issuance of Loans and Achievement of Targets. It's a departmental, it's cross-filed with Senate Bill 247. There's no state or local fiscal impact. The note goes on to state that authorizing DHCD to provide loans in addition to grants, which is the current law, for specified energy conservation and renewable energy projects does not materially affect state finances or operations. But that expanding eligible funding sources for greenhouse gas savings significantly reduces special fund revenues and expenditures for DHCD. There's an amendment from GHHI, the Green and Healthy Homes Initiatives, which was sent out to the subcommittee. The testimony is otherwise all favorable. I can pull up the amendment really quick, Chair Holmes.
Please, please.
Okay. And I'm just sent a request. I just sent a request to share. Yeah.
Send a request.
Yep. And now I got it. Thank you.
Okay, thank you.
Okay. It's a minor amendment, pretty straightforward. And while we go through the amendment really quickly, I'll also go through the more substantively what the bill is doing. The bill is focusing on greenhouse gas emissions in Maryland by doing two things. You can see the word loans is added here after grants. Basically, that's because loans are more beneficial for capital financing for grants. Right now, they can just do loans. The program provides, this greenhouse gas reduction program provides funding for projects targeting emissions reductions in multifamily residential buildings, specifically those housing low-income households. And the grants are through, in the greenhouse gas reduction program is through the Multifamily Energy Efficiency and Housing Affordability Program. The bill is also expanding eligible funding sources that can be used for achieving the emissions reduction targets defined in a provision concerning efficiency and conservation for low-income individuals, which is on the screen right now. The amendment from the Green and Healthy Homes Initiative is friendly by the department, and what it's doing is it's changing back this language here in line 33 to existing laws so that the intent of DHCD is to continue to seek additional funding resources to scale their programs for these energy goals. I think the way it's just kind of the word choice, they thought it was better for it to be procure or provide instead of be just include savings. So yeah.
Thank you, Ben. I move the amendments.
Second.
Let's have a discussion on the amendments, if there are any. They seem to be pretty straightforward. Any,
I have a quick question, Mr. Chair.
sir?
Ben, I might have missed it. Does the bill mention if the responsibility for this falls to MEA or DHCD, or is it agnostic on that piece?
Yes, the responsibility for the procuring and providing savings or
Yeah.
that's the terminology in the bill right now is the department doing that, but I can also defer Chair Holmes to the DHCD folks if that's helpful.
Yeah, let's first off, that question that Delegate Allen is asking is not to the amendments. However, the question Delegate Allen is asking is to the bill, but that's okay. Let's see whom he is on the call that can answer that question for Delegate Allen. I'm scrolling through, who is here?
We do have Chuck Cook from DHCD. Chair Holmes.
Oh, Chuck, there you are. Chuck, is it possible for you to unmute yourself? Thank you, sir. And Delegate Allen, if you could ask your question again for Mr. Cook, if you don't mind.
Yeah, I just wanted to make sure that the department that's specified here is in fact DHCD. Is that accurate, Mr. Cook?
Yes, sir, Delegate. It only applies to us in what we procure and provide. That's correct.
Great. Thank you.
Thank you, Mr. Cook. Thank you, Delegate Allen. And I saw another hand. Oh, Delegate Naraki. Yes, sir.
Mr. Chair, I do have a question, but it's not on the amendment, so I can hold if you would like until
Please.
we've gone through the amendment. Yes, sir.
Yes, sir. Let's just go through the amendments. Let's just get finished with the amendments first. We have a motion and a second on the amendments. Any additional questions on the amendments? I'm scrolling through. I see no hands on the amendments. All in favor of the amendments signify by saying aye.
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 Any opposition to the amendments? Hearing or seeing none, the amendments have passed. I move favorable on the bill as amended. Is there a second?
Second, Mr. Chair.
There's a motion and a second on the bill as amended. Questions, please. Delegate Naraki.
Thank you, Mr. Chair. I think I know the answer to this, but I just looking at the fiscal note, but I want to understand for sure. So is the funding source for this the Empower Maryland program?
Yes, sir. Either Mr. Cook or Ben can expand upon that. I think that's correct, but go ahead.
That is correct, Delegate Naraki.
Mr. Chair, may I have a follow-up to that?
Yes, sir, please.
Thank you, Mr. Chair. And maybe, Mr. Cook, maybe this is appropriately directed to you then, sir. So would this potentially increase the amount that someone could be paying on their electric bill to the Empower Maryland program, or does it have no effect? I'm just trying to understand what that means to ratepayers' bills with respect to Empower Maryland.
It's a good question, Delegate. No, this has no effect on actually what ratepayers pay. All it is it's a technical bill that allows us to account for the actual savings that Empower does on the greenhouse gas reduction side. So it addresses funding sources not at all, and it addresses spending not at all. It's about accounting for the actual carbon emissions that come from it on behalf of DHCD and what we procure and provide with Empower.
Okay, thank you, Mr. Cook.
Sir.
Thank you, Delegate Naraki. Any additional questions on the amended bill? I'm scrolling through to see if I see any hands. I see no hands on the question, no additional questions on the bill as amended. All in favor of HB 155 as amended signify by saying aye.
Aye.
In opposition? Seeing no
No,
opposition?
sorry, Mr. Chair, I wasn't quick enough. No, sorry.
All right.
Sorry.
Anyone else opposed to HB 155 as amended? Seeing none, HB 155 as amended will receive a favorable report from this subcommittee. Ladies and gentlemen, let us now go to HB 222. This is something that we've heard before. This is CSST, corrugated stainless, the piping stuff, CSST. Ben, can you take us through the amendments, which I think is going to make everyone very, very happy? Ben, can you take us through the amendments, please?
Thank you, Chair Holmes. I'm sharing my screen now.
Okay.
We had a discussion last week on the bill. The subcommittee got to take a look at the bill and the general form that it was taking. Following that discussion, there was just some final points that we looked at for the bill. It says one thing we're looking at is what entity will be conducting the study for the fire hazards associated with fuel gas piping systems, which include the gas piping and corrugated stainless steel tubing, or CSST. That was determined to be the Office of the State Fire Marshal. They were the other, I think, kind of just discussion point, Chair Holmes, was sticking with the language as currently drafted in 19108A here. A person may not sell, offer for sale, transfer, distribute non-arc resistant jacketed corrugated stainless steel tubing, period. Again, the terminology was based on what's in the existing law, which you can see in 12206B here, line 13. It's the same term. That 12206B, again, is just for the use in construction. But the 19108 is for the sale, offer for sale, transfer, distribution. So that kind of closes all the, the possibilities where with a non-arc resistant jacketed CSST. It doesn't have that qualifier though about the ANSI LC1 standard for non-arc resistant jacketed CSST, but that again is in keeping with what's the current law there in 12206B. The effective date of the bill is going to be June 1st, 2025, which the subcommittee saw last week as well. And then we also added manufacturers of fuel gas piping systems and corrugated stainless steel tubing to one of the entities that the office for the fire marshal's office is going to be consulting with when conducting the study.
And what I wanted to do is to make sure everyone understands that we have removed the standard for the 36 coulombs and the items there that appear to have made this a product that only one manufacturer was making, and this is turned into a study so that we can understand how the effects of this is. I make a motion on the favorable motion on the amendments. Is there a second, please?
Second.
Thank you very much. We have a motion on the amendments and we have a second. Any question on the amendments? Seeing no questions in the amendments, all in favor of the amendments on HB 222 signify by saying aye.
Aye.
Any objections to the amendments? Let me scroll through here. I see no objections on the amendments. I move favorable on the bill as amended. Is there a second?
Second.
Any discussion on HB 222 as amended? I'm seeing none. All in favor of HB 222 as amended signify by saying aye.
Aye.
Any objections to HB 222 as amended? Hearing none, HB 222 as amended will receive a favorable report from the subcommittee. Thank you, ladies and gentlemen, on that one. Now let's move to HB 390 and HB.
Chairman, Mr. Chairman.
372?
372?
I'm so sorry. Do I appear to be rushing you all? Yes, I am. I was trying to make it so you didn't notice it. I'm so sorry. We will go back to HB 372 and Ben, give us a brief discussion on HB 372, please.
Okay, thank you, Chair Holmes. The title of the bill is Prince George's Gateway Development Authority Sunset Repeal. There's no state or local fiscal impact. There's no amendments. The testimony is all favorable, including from the city of Mount Rainier and the town of Bladensburg. Has a unanimous letter from the delegation. The authority, the Prince George's Gateway Development Authority, supports the development and approval of a comprehensive neighborhood revitalization plan for the community in the target area of the county, which encompasses the cities of Mount Rainier and Bladensburg and the towns of Brentwood, Cottage City, Colmar Manor, and North Brentwood. The previous law that was passed had a sunset provision. This is repealing that, making the authority permanent. The last thing in the fiscal note, it's stated that although the bill only repeals the termination date, there may be an expectation of future funding. And then they cite the West North Avenue Development Authority as an example of that.
Thank you, Ben. Ladies and gentlemen, can't get much easier than this. I saw as a motion and a second favorable on HB 372. Any discussion? Seeing no discussion, all in favor of HB 372 signify by saying aye.
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 Any opposition? Let me scroll through. I see no opposition. Therefore, HB 372 will receive a favorable report.
Was that a landslide, Mr. Chair?
That is a landslide.
Oh, okay. Thank you, Mr. Chair.
Let's keep it rolling, Mr. Chair. Let's not break the chain.
Moving on now to HB 390. HB 390, if you could, Ben, give us a brief description on that one.
Alrighty, thanks, Chair Holmes. The title of the bill is Affordable Housing Payments in Lieu of Taxes Expansion Act. It's cross-filed with Senate Bill 327. There's no state or fiscal impact. For the local fiscal impact, the note says that property tax revenues may decrease beginning in fiscal year 2026 to the extent that certain rental properties are exempt from real property taxes. ENT is secondary on this bill. Ways and Means has voted the bill out with the amendments that are that I have before us here on the screen. The bill concerns property taxes and payments in lieu of taxes and affordable dwelling units. So going to the substance of the bill here, what the bill is doing is authorizing county governments to exempt real property used for rental housing from the county property tax if the owner, and that's going to be in B1, B and B1 and B2 here, if the owner enters into a payment in lieu of taxes agreement with the county government. And then two, if the owner is the owner of the real property maintains at least 25% of the rental housing units at the property as affordable dwelling units for at least 15 years. The amendments from Ways and Means, as you can see, reduce this from 50 to 25%. And there's also this added provision here that authorizes in subsection C, the governing body to require a higher percentage of affordable units. Real quickly, affordable dwelling unit is a dwelling unit that is affordable to households earning 60% or less of the area median income. And affordable, as mentioned in that definition for affordable dwelling unit, means that housing costs do not exceed 30% of a household's income. The bill takes effect June 1, 2025 and applies to tax years after June 30th. There was testimony from AOBA that urging the committee to reduce the threshold for obtaining a pilot from 50% to 30%, which I believe is addressed by the amendments. Greater Bethesda Chamber of Commerce had the same favorable amendment. Baltimore County wanted 20%.
Thank you, Ben. So we kind of split the baby went with 25. And these are amendments from Ways and Means. Is that my understanding that correct, Ben?
That's correct.
All right, so let us do this, ladies and gentlemen. Let's get a motion on the amendments first, and then we'll go to discussion. Megan, I move favorable on the amendments.
There's a second.
And there is a second. We are now on discussion of the amendments. Delegate Healy.
Yes, I just wanted to ask if this conforms it to the Senate bill, or is that what we're doing the amendments for?
The amendments that we just that we are in discussion on are the amendments from Ways and Means.
Okay, but do they match it up with the Senate bill?
Ben?
Yeah, thank you, Chair Holmes. The Senate bill is in committee still.
Oh, okay.
I'm
Thank you.
unaware of amendments for the Senate.
So we still have control. We have control of that right now.
Got it. Thank you.
Any other discussion on the amendments for HB 390? Seeing none, all in favor of the amendments on HB 390 signify by saying aye.
Aye.
Any opposition? Seeing none, I make a motion favorable on HB 390 as amended. Is there a second?
Second.
And there's a second. Any discussion on HB 390 as amended? And scrolling through, I see no hands up for discussion purposes. All in favor of HB 390 as amended signify by saying aye.
Aye.
Any opposition? Seeing none, we will receive a favorable report from the Housing and Real Property Subcommittee. We will now go to HB 1085. And Ben, if you could give us a brief discussion on HB 1085, I certainly would appreciate it.
Okay, thanks, Chair Holmes. So let's see, for 1085, I'll pull up the bill too.
Thank you, sir.
Because I think there was some discussion of amendments. I'll just go through it like that. There are no amendments. There were not amendments sent out, but I'll go through the amendments that were identified. Let's see, there's no state or local fiscal impact. The amendments discussed, we'll get to, there is also a technical amendment that's going to be made to the purpose paragraph, depending on what happens in subcommittee here, but that is just a technical amendment. So generally, what this bill is about is housing authorities and what is a housing authority, and then the nonprofits being controlled by a housing authority and the property related to that. Okay. So the first part here of the bill is about what housing authority's definition is. It's an entity, and then there's some repealed language that is controlled or wholly owned by an authority. And then it also says, or in which an authority or an entity controlled or wholly owned by an authority has an ownership interest through one or more subsidiary entity. Okay. Let's see, the next part of the bill is this subsection B here, which is stating that a nonprofit entity shall be deemed controlled by an authority. So this is the nonprofit part. A nonprofit entity shall be deemed controlled by an authority if, and then we have down here, the nonprofit entity is established by an authority, and the authority either has the power to appoint a majority of the board of directors or is the sole member. So basically, it's controlled by the authority. Moving down a little bit more, this is, let's see here, in page 4, lines 1 through 3, property is used for essential public and government purposes, and is exempt from all taxes and special assessments. This is about like the property that's being used and how it's going to be exempt from taxes and special assessments if the property belongs to an authority or a nonprofit housing corporation in paragraph I there. Okay, and then and then it says, let's see, belongs to an authority or a nonprofit housing corporation, is used as housing for persons of eligible income and controlled by a housing authority. And then there's this last part here where it says, or is used, or if under construction, will be used as housing for persons. So those are kind of the three things here for being exempt from all taxes as stated in paragraph 2 there. The property is exempt from all taxes if it belongs to an authority, is used as housing for persons through one or more of their subsidiaries of the authority. And then paragraph 3 is, or if it's used or under construction and will be used as housing, subject to the fact that it has to have improvements and that are by the authority or an entity controlled by the authority. So that's kind of like the general thing about going on with the bill. I just want to note the Housing Authority of Baltimore City was requesting that we add or will be used in line 25 here, instead of just saying is used. Well, it should say is used or will be used. The only thing about that is I was a little worried it was too broad, because will be used kind of sound like generalized and like indeterminate. So I asked them about like how paragraph 3 there is talking about the construction being used, and that's kind of like more contemplation about the will be used, because like is used or if under construction will be used, but they thought that it was a little bit too restrictive how it's talking about the improvements, and that sometimes that can be a problem for them, they were saying. So I'm flagging that. And then the last thing, Chair Holmes, is Mako. We're looking at paragraph 3 here. Basically, I think the Mako testimony might not be, I don't know, you guys can see, but the what it's saying for 3 is that their kind of contention seemed to be with the existing law, not really the bill. So they're saying that allowing but not requiring, because allowing but not requiring these payments in lieu of taxes creates uncertainty. But my understanding is that that's a problem with the existing law. And so it's not really a problem with the bill itself because, yeah, as you can see. Yep. Okay.
Thank you, Ben. And there was a technical amendment. What does that entail?
There's a technical amendment to the purpose paragraph.
Oh, I got you. That's fine.
Yeah,
That's
yeah.
fine. And I'm going to anticipate Delegate Boyce's question. Can you go back to the questions about what Baltimore City was asking?
Thank you, Mr. Chair. I'm sorry, Ben, you said you did speak to the Housing Authority?
Did I can I was speaking with them today and I can
Okay.
let me try to find that.
'Cause I thought their issue was that sometimes,
And that's why they wanted to use
a multi-phase process
is
and
used
when they
or will
acquire
be used.
property.
Yeah, is used or will be used, I think is what they were looking at.
Yeah, I can read like an excerpt of their email if that's helpful.
Yes,
Sure.
indeed.
Okay, so it says we are requesting the language or will be used to be included because often when the Housing Authority of Baltimore City or their development instrumentality acquires land to be redeveloped for affordable housing, there can be a considerable amount of time that it takes to close financing deals and do site assembly, that type of thing. And so the language in the current bill, I'll just show again real quick here. They were saying the language in the current bill talks about property on which affordable housing already exists or construction is underway, which is in 3 there, in line 29. And we feel that our requested language is necessary to specify that property that is vacant and awaiting redevelopment is also included as tax exempt.
Let me ask a question here, Ben. Keeping the language is used, that would be applicable to the city's concerns if they got into the program either now or up to a certain date, I assume. What would that date be?
So I'm not sure about the dates, Chair Holmes.
Okay.
My kind of like I kind of zeroed in on their contention about adding is used or will be used
be
for
used.
that line 25 there.
Kind of, Delegate Boyce, since you
I mean, the
brought
question is does the current language allow them through this process to still have those properties kind of as a tax exempt if
Yeah,
they're in the process? Because that's what it sounds like.
yeah, and that's kind of where I was going. I didn't state it properly, but
Yes.
yeah, that's why I'm thinking.
I mean, we talked about that in committee today regarding the permitting process, right? Like you can buy the property or be in process of the property and just still be in process knowing maybe the property will be used as affordable housing or per the housing authority, but then like if you're in kind of like a limbo, like how does this?
Let's get Ben to chime in on that.
Okay, yeah, thanks, Chair Holmes. Just real quick, I did ask the sponsor of the bill as well, and they weren't opposed to the amendment requested from the Housing Authority of Baltimore City. But yeah, in regard to the comment from Vice Chair Boyce, I guess the just that what their kind of concern was property that might be vacant but not necessarily qualify under 3 here because it wouldn't have improvements or improvements under construction. So that, yeah.
Mm,
Can I make a suggestion, Delegate Boyce?
yes.
Can we move as it is and then bring that back up in full committee?
And bring the amendment in committee?
Yes,
I'm happy to do that.
thank you very much. We can discuss it additionally in full committee. Let's do this. We have amendments in front of us. Make a motion to move the amendments. Is there a second?
Second.
Is there any additional discussion on the amendments? Seeing none, all in favor of the amendments signify by saying aye.
Aye.
Any opposition to the amendments?
Move the bill.
Is second? I second. Any discussion on HB 1085 as amended? Seeing none, all in favor of HB 1085 as amended, signify by saying aye.
Aye.
Any opposition to HB 1085?
Aye.
Is that Ryan, Delegate Rocky? No, okay, I'm sorry. I thought I heard an aye. So everyone's in favor of HB 1085 as amended. Thank you, ladies and gentlemen. That will receive a favorable report from the subcommittee. Let us, ladies and gentlemen, and if you don't mind, Delegate Boyce, if I can give you a homework assignment to look at that amendment that was suggested by the city and see if you can flesh that out with Delegate Voigt, Ben Voigt, if you don't mind.
Yes, I'm happy to do that. Thank you, Mr.
Thank you so much. Let us now, ladies and gentlemen, go to HB 767. And HB 767 will be for discussion purposes only, ladies and gentlemen. And I want us to take a look at this with full gusto so that we can make a decision on what we're going to do next week or later. Yeah, next week. Ben, you have the floor.
Okay, thank you, Chair Holmes. HB 767. I'll pull up on the screen, Chair Holmes. Yeah. Okay. So let's see. It's cross-file with Senate Bill 442. There's no state or local fiscal impact. This is a landlord and tenant bill. It involves eviction from premises and notice. The bill establishes requirements related to this notice and the storage of a tenant's property. The bill also establishes civil remedies if for a tenant if a landlord is in violation of the bill. On June 10th, 2024, the Fourth Circuit ruled in Todman versus the mayor that Baltimore City's eviction law is unconstitutional. This law and then similar local laws declared a tenant's belongings abandoned upon eviction without adequate notice in a reclamation period. And so that's kind of the impetus behind a lot of the bill, I understand. And the issue is about renters getting their notice before an eviction and the opportunity to collect their belongings. Okay, having said that, the first part of the bill, we're looking at the types of evictions or the types of breaches. So we have 8401 is failure to pay rent. So what the next few pages are going to be doing is provide that the eviction procedures in the rent cases comply with this new section 8407 that you can see added there. It's also making some like technical changes, but that's mainly what's going on. 8401 is for failure to pay rent. 8402 is for the tenant holding over. The warrant of restitution that you're seeing, that refers to the return of the premises. It's kind of like the sheriff is executing a warrant of restitution to return the premises to the landlord. And then 8402.1 is is a breach of lease. Okay, and then now we're at 8407, which is kind of where the substantive provisions of the bill begin. Subsection A here is for each type of the eviction that I mentioned earlier. Subsections B and 1 is about the notice on a number of things. Let's see, after a court has issued a warrant of restitution, the landlord 14 days before the scheduled date of repossession is providing this notice to the tenant by first-class mail and by posting on the front door and a date stamp photograph. Okay. Moving ahead, these are some of like the notice things. That's the address, the date of the eviction, a statement that repossession can occur. Let's see. And then for Roman numeral 6 here, this is that the repossession is going to occur unless the tenant returns possession of the leased premises to the landlord, or for a warrant of restitution, exercises the right of redemption. let's see, Roman numeral 7 is providing that if the tenant has a right of redemption, they can provide a statement showing the amount still due. Roman numeral 8 is that a statement that if the eviction does occur, this is again just for that notice provision, within 10 days after the eviction date, the tenant can reclaim all of their property that was in or around the lease premises. And that after these 10 days, the tenant's remaining personal property is going to be considered abandoned and maybe disposed of. Those are two other important provisions to note. There's Roman numeral 9 here. It's a statement informing the tenant as to how the tenant may obtain any personal property left or on or about the premises after the eviction occurs. Roman 10 there is a statement that the notice is the final notice to the tenant, even if the repossession is stayed for any reason. Here's the telephone number at which the landlord can be contacted about this. Let's see. Paragraph 4 concerns a presumption that if the landlord shows up for the eviction with the certificate of mailing and a photograph and affidavit about the notice, that the sheriff should be proceeding with the eviction. Okay. Paragraph 5I is providing that if the sheriff reasonably believes that the landlord has not provided the notice, the sheriff shall notify the district court and is not going to execute the warrant of restitution. And then the district court can find that the landlord did not provide the notice required and vacate that warrant of restitution. Let's see, subsection C there is that the sheriff is filing documentation with the clerk and executing the warrant by if the landlord presents the documentation, the sheriff is filing the documentation with the clerk and then may execute the warrant by putting the landlord in possession of the premises without the removal of any personal property, though. Subsection D is if the tenant is not present for the eviction, the sheriff is going to be posting a notice stating that the eviction occurred and to contact the landlord about reclaiming their possessions within the next 10 days. Okay, and then E1 is the tenant has these 10 days to recover their property from the premises or another reasonably secure location. The landlord may not charge a tenant any fee for storing their property during this period. During the 10-day period, the landlord shall be making the tenant's property reasonably available so that they can recover it, and the landlord's not liable for any losses relating to this property. A tenant can't waive the right to reclaim personal property. Subsection F, the landlord and the tenant, unless they agree otherwise, the personal property remaining on the premises or in the secure location following the 10-day period of this section is going to be deemed abandoned, and the landlord or any person acting on their behalf may not be held liable. This is a paragraph 3I is about the disposal of the property. They can do that a number of ways. Property deemed abandoned under this subsection may not be placed in a public right of way, and a landlord is not prohibited from disposing of. There's more information about the disposal. Subsection G is nothing can be interpreted to restrict the authority of state and local jurisdictions to enact legislation governing landlords and tenants, including penalties for violating this section. And then the last subsection of the bill is H, which is that if the landlord finds in favor of a tenant based on a violation, the tenant is entitled to damages, attorney's fees, injunctive relief, and any other costs, and it applies prospectively.
Thank you, Ben. If you could go back to Roman numeral 9 there for a minute, where it talks about tenants to obtain the property. And I want to see if we can get a little bit more discussion. So according to this legislation, one of the ways that we could adhere to the circuit court decision, and I'm going to ask a question to Professor Google here in a little bit. Um, one of the ways we could adhere to the Fourth Circuit, the landlord could in fact hold the tenant's property inside of the unit, and that would that's what the bill is asking for. Am I understanding that correctly? And 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 when and when the landlord holds the tenant's property inside the unit, the landlord has to provide the some kind of notice in terms of where the property is. And I'm just kind of confused in terms of if the landlord is holding the property on the premises. Want to go and look at that number 9, Roman numeral 9 notice again. Statement informing the tenant as to how to obtain the personal property. That could be, I'm assuming, something as simple as you, Mr. and Mrs. Tenant, can call me at this number. I can come unlock the door and you can get your property. Is that what I'm assuming here, Ben?
Mr. Chairman,
Yes, sir.
in all probability, the tenants still have the key to the property.
Well, let's hang on a second, because I think that let's go back then. If that is one concern, the eviction process still takes on its normal process in that when the sheriff gets there, the locks can be changed. That was my assumption from the very
That's true.
beginning.
Yes.
Uh, Can you verify that, Ben? And we also have Sheriff Carr on the line too, if we need to go to him. But I'm sure Professor Google can straighten this out here, since he's going to be a Supreme Court sitting on the bench pretty soon anyway.
I can give it a shot.
All right.
First of all, this is the best job. No one should leave here to join the judiciary. This is the best branch of government. But secondly, my understanding of this is that we're not really being prescriptive at all about how the reclamation happens. I mean, to first answer your other question, to Delegate Ciliberti's point, most of the time, I mean, if not 99% of the time, after an eviction occurs, the tenant is not going to have access to the property themselves. They're not going to have the key. So I can answer that. In terms of the bill and what it says about how you pick up your stuff, I think the bill is purposefully not prescriptive about that, because I think that there are myriad ways that a landlord and a tenant could work that out. Some landlords, for example, do not have any real turnover period more than a day or two between a tenant moving out and another tenant coming in. And in those cases, the landlord probably would want to put this stuff in a storage unit, which may be more cost effective anyway. And then the notice here that you were referencing, Mr. Chairman, would probably just be something like, text me at this, or here's the address of the storage unit, email me and I'll give you the code or whatever. Some landlords, I'd probably say the majority of them, and probably the better practice, is to wait until your old tenant is fully out before you sign a new lease with another tenant, because otherwise you get into some real problems. And for those landlords, they're probably more likely, Mr. Chairman, to keep the belongings in the unit, and that may be more effective for them. But I think that the key here is not to spell out exactly how this handoff has to take place. And in my understanding of looking at other state laws, because again, we're really the outlier here. That's why the Fourth Circuit said that we were unconstitutional. If you look at like West Virginia and Pennsylvania, they provide 30 days reclamation period, for example. And those are not exactly like left-wing or pro-tenant states. But the reason none of them spell out exactly how the handoff has to occur either. They all have this same kind of language where it's like, there's a reclamation period and like, y'all are adults, like figure it out.
Thank you, Supreme Court Justice Stewart. Sheriff Carr, I saw you were there. Would you like to add something, Sheriff Carr, to our discussion, if you don't mind?
Yes, and good evening. Thank you for allowing me just to speak and just add something to that. I think the bill does not define as far as that eviction period. I would go over the process in which the locks are changed. if this bill were to pass and the actual property were to remain inside of the residence, the concern I would say just from law enforcement is that you will have issues to where you have a property owner who is owed money now holding on to someone's property. And the concern is how that is going to be made readily available. I know in the bill, it does lay out that it does give the tenant, if the property owner or landowner does not provide the necessary 10 days or provide the ability to obtain their property, that they could go back to courts, which is a longer period in time in order for that to happen. But my real concern is that we will have individuals that will take this into their own hands. And we then would probably see whether break-ins or you're talking about loss of property that we would then be dealing with, not only just from the court standpoint, but also in the initial as far as I would say police reports being taken with those items still being there. An eviction is already an emotional time frame. So to come home and then to not have access to your property, individuals, again, still may take it into their own hands and then actually try to gather those items. So there is some concerns that I do see, but as it stands, as far as the eviction process, the locks are changed and we do talk to the tenant, or we at least currently right now here in Prince George's County, all of the property is placed out so that they can actually have access to it. If there was any complaints or any issues as far as the property, that again is where we would then interact with them.
Thank you, Sheriff Carr. And the current scenario, Sheriff Carr, if I could ask to expand upon it, is that during the eviction process, the crew takes the items and places them outside of the unit someplace as the locks are changed. Is that correct?
To the major roadway, yes. So our responsibility is to, one, secure the property as far as staying inside the residence as the crew is actually moving those items outside of the home, and then also making sure that they place those items at the thoroughfare where it's off of to the main roadway. So we're actually making sure that items such as anything that medication, weapons, pornography, anything that may be a danger to the public, we do not place those items out. Those are the only items currently that actually stay in the property. Everything out is removed, and that is to make sure that the property owner has access to that property.
Thank you, Sheriff Carr. And there's a time frame. Do you ever come back to where those properties were laid out on the in front of the property to look to see if anything has taken place, or after the eviction takes place, your responsibilities have terminated and you move on to the next case, I guess? That's what I'm asking.
Depending on the situation, but yes, it would be that once those items are out and we secure it and it is at a location that we have now completed that eviction, and then we do move on. But depending on the items that are out, as far as large items, we do notify the municipalities. We also notify our DPI department that these items may be there, that we also know that, hey, this is something that you couldn't get with a U-Haul or a truck, but we want to make sure those items have just been notified to the local jurisdiction that, hey, they're there on the major roadway.
Thank you, Sheriff Carr. I'm going to go to Delegate Naraki, and then I'm going to come back to Delegate Stewart. Delegate Naraki, you have the floor.
Thank you, Mr. Chair. I'm definitely ready to have some discussion. I have a couple questions here, Mr. Chair, if that's okay.
Yeah, certainly.
I have my first question is, I'm just kind of going through the different timelines that are established in 8407. And so the first question I have is about the 14 days before the scheduled date of repossession. Is that 14 days a new time frame there that does not currently exist in law?
Ben, that looks like that's new. Ben, looks like new language to me.
Yeah, yes, Chair Holmes. I mean, that's right. I think this is I think it's this date, but then it's also there's also the 10-day period as well. So there's
yes.
Yeah.
And Ben, that was going to be my next question. So the next question, of course, is that the 10-day reclamation period is also a new timeline that is not currently in law. That's the meat of the bill here, essentially, right? I'm just making sure that I'm operating off of proper timelines.
Yeah, yes, I have that provision up to right now. And then, yes, Chair Holmes, I'm not sure if Delegate Stewart is wanting to add anything. But...
So if I may, about that time frame. So are we talking about kind of a new 24 days, as I read that there, of to work through the process that's in addition to kind of the timelines that are already spelled out in the eviction process?
I think it's going to depend on a couple of factors about like how the eviction is proceeding. Yeah.
Okay, maybe I should rephrase, Ben. If everything worked to sort of the maximum length of time here, that 14 days, 10 days, or is it theoretically an additional 24 days in the process? Maybe word it that way.
That's my understanding, but I'd want to double check that.
That's my understanding as well, but I will let Ben double check that to verify, and we'll make sure we get that definitive answer to you, Delegate Naraki.
Mr. Chair, may I ask two more? Is that
You
okay?
certainly may. You
Okay.
certainly may.
Okay.
You certainly
Thank
may.
you, sir. Who, obviously, as the sheriff just pointed out, this process can be contentious. I'll say it that way at times when someone is being evicted from a property. With this new reclamation period, would there be an expectation that the sheriff or some other law enforcement body that I'm not thinking about would be present when someone would potentially come back to reclaim their possessions? I'm just worried that we could be setting up some really contentious situations where it's just the landlord and or the property manager and a tenant, if there's not like law enforcement there when possessions are being reclaimed.
The way I read the bill, Delegate Naraki, there is no law enforcement required to be available. For example, when the tenant leaves the property in the unit and the tenant makes a appointment with the landlord to come reclaim it, I don't see, unless Ben can point to something different, I don't see where there is a suggestion of where law enforcement accompanies those. Ben, can you correct me if I'm wrong, if you don't mind?
You're right.
Or Chair Holmes. So I think the first part of that is we have in C2, if the landlord's presenting the documentation that's required, the sheriff can file that with the clerk and then execute the warrant of restitution and put the landlord in possession of the premises without removal of any personal property. So
yeah, that would suggest to me that it's going to be after the eviction takes place, it's between the landlord and the tenant and how those properties are going to be repossessed. But we'll take a look. If you have suggestions, Delegate Naraki, please.
Well, Mr. Chair, I think law enforcement should be present to minimize the chance of negative interactions there. I understand there could be certain circumstances where there wouldn't be. Maybe it's amenable in some way, but I could see how there could be circumstances where this could go very wrong. Between a tenant and a property manager or someone like that there.
I certainly understand it. My concern is on both sides of the coin. Number one, my concern is making sure no one gets hurt. My other concern is sheriff's departments and police departments are already stretched very, very thin. But let's move on.
Yes, sir.
And let's see if we can find a solution halfway in between there someplace. I'm going to go to Delegate Stewart, then Delegate Boyce, and then Delegate Healy. Delegate Stewart, you have
Thank you, Mr. Chair. So just like some quick thoughts based on what we've heard so far. So first of all, about the question about whether this is new law, about the 14 days, I will note that while Ben was totally correct that this is all new language, Baltimore City actually already does have a 14-day period of notice. So that is existing law in Baltimore City.
That is correct.
And I'll also note that despite that 14-day notice, their law was still struck down in Todman as unconstitutional.
Yeah.
Because of their lack of a reclamation period. Number two, to Delegate Naraki's point about does this add 21 days to the process? No, the answer is not quite, because evictions are very rarely scheduled. They cannot be scheduled within 5 days of the warrant restitution being granted. So that's 5 days right there. You can never have an eviction because there's an appeals process that has to play out. You have to give tenants the ability to appeal. Even then, especially in our bigger jurisdictions where the sheriffs are busy, you're not going to see evictions usually on the 5th or the 6th or the 7th day. It's oftentimes going to be later. It's oftentimes going to be weeks later. And I think the point of the bill is it creates this really weird situation for tenants where they don't know when it is. They kind of are incentivized to play chicken a little bit because you don't want to move early if you don't have to, because it's going to be harder to get a moving truck. It's going to be harder getting movers out there. But that the ambiguity about when the date happens is why I think the current system leads to a lot more contentiousness. But just to the point about it does not add 21 days to the process, even the 14-day notice. And of course, we could lower that. I mean, as the point I've made multiple times now is, we have to comply with the Constitution, right? So my view is that we've got to do something. Maybe 14 days is not the right number, and we can have a conversation about what number is better. I do know some jurisdictions have 7 days. As I mentioned, other jurisdictions near us have 30 days. Baltimore City currently already has 14 days, but it does not actually add 21 days to the process. It might add, based on an average eviction, maybe a few days before the eviction happens. If you did 14-day notice, if you did 10-day notice, maybe you wouldn't really add anything at all. And then lastly, I just want to just put in a little bit of a finer point on the contentiousness. I certainly trust, Sheriff Carr, and I certainly trust his views on this because I've never conducted an eviction. But what I will say is that I think that you can make an argument about contentiousness and the possibility of violence and emotion on both ends, because the current system also makes people really angry and pissed off. And I think for a really valid reason, because they don't know when someone's coming. The sheriff shows up at the door. They don't know that's the day. And then all of their possessions are put on the street. To me, that would I'm not going to fight the sheriff personally, but I am much more likely to get angry with the sheriff if someone, or with anyone, if someone comes to my house unannounced and puts all my stuff on the street, than if I get a nice little notice in the mail that tells me when my eviction will occur, what all my options are for avoiding the eviction, and what happens if I leave stuff behind, and lays out the whole process for me. And then once the eviction occurs, if someone tells me, hey, Vaughn, your stuff is in a storage unit, I may be a little bit mad, but I'm going to be way less mad than if my stuff is being picked through by strangers while it's raining on the street. So I think that you can make a contentiousness argument on both sides here. I certainly get Sheriff Carr's point, and I'm sensitive to it, but it's not obvious to me that the scenario laid out in the bill is going to generate more anger and emotion than the status quo. Lastly, I will note that I did talk to some of my sort of tenant advocate friends that I know that I went to law school with in other states, and they've said that this whole reclamation period thing, they're not aware of. I asked a couple, and one is in Pennsylvania and one in New York. They said they weren't aware of any incidences of violence during the reclamation period. So I also tried to, given my Professor Google reputation, Googled this a little bit. I couldn't find any press incidences or any accounts at all of a tenant being violent during the reclamation period. And I'll also note, to the point about having a law enforcement official present, the landlord is not required to be there during the reclamation period at all. The landlord could simply, especially if they were worried that the tenant was going to be violent or had some sort of tendency towards violence, you could easily just provide a code to a storage unit and say, hey, bro, here's the address, here's the code, all your stuff's in there. Good luck. Sorry that things ended badly. And you never have to see him again. Similarly, if the stuff was there and the landlord had to actually unlock the key still in the unit, the landlord would always have the option to get the sheriff's office involved. And we can ask Sheriff Carr if that's incorrect. But I don't think the sheriff's office is going to ignore a phone call from a landlord that says, hey, I know the bill that the legislature passed doesn't require you guys to be here, but I feel a little bit threatened to my life, because this tenant has, I don't know, a criminal background, or he was regressive with me before, or he's been sending me some threatening text messages. He's about to come over to the unit. Mr. Sheriff, could you please just join me while I unlock the unit, while I unlock the door and let him get his stuff out? I'm sure the sheriff's office would be happy to oblige in those very rare instances. I appreciate
that. This is what I want to do. I want to give. We're on a topic that Delegate Naraki brought up, and I think he might have a follow-up question. So I'm going to give Delegate Naraki the opportunity to do a follow-up question on this topic that he brought up. Then I'm going to go to Delegate Boyce, Delegate Healy, and then, if you don't mind, Delegate Addison, between Delegate Naraki and you, I'm going to go back to Sheriff Carr, and then I'm going to come back to you, Delegate Addison, if you don't mind. So right now, let's go to Delegate Naraki first, and then Boyce, and then Healy, and then Sheriff Carr, and then Addison.
Thank you, Mr. Chair. And to my colleague, Professor Stewart, I certainly appreciate all of that. And Delegate Stewart, I definitely was thinking about it on both sides of the equation there. I wasn't necessarily implying that it could be just on the tenant side. I think you're right. There could be on both sides of the equation there with the landlord as well. I do have a question, and maybe Delegate Stewart could answer this one, or maybe it's someone else. But you referenced West Virginia, Delegate, that they have a longer reclamation period, 30 days. Was that one considered constitutional by the court, that 30-day period?
I don't think that there's been a court case on West Virginia's law.
Yeah, this was Fourth Circuit in Maryland.
West Virginia and Pennsylvania have 30 days. There are jurisdictions that have also not been deemed unconstitutional that have 7 days. So I think that we have a few options before us in terms of the number of days. I don't think we necessarily have to do 30 to be constitutional. I don't think that we necessarily have to do 14 to do constitutional, but we also probably have to do more than like 3. You know, I don't know. I mean, the court didn't spell it out in the case exactly what the right number is, so we do have some flexibility in that regard. But the only case that has held any scheme like this unconstitutional is this Todman case about our scheme.
Sure. No, but and thank you, Delegate, for that. It is my understanding, though, also that West Virginia has 30 days, but they also require the tenant to pay for that holdover period for the 30 days. So I think that is different than what we're suggesting here, right? Because there's no provision to require any sort of payment for that 10-day period. So I would say that that's a pretty significant difference between the two there. I think you would agree with me on that.
Thank you, Delegate Naraki. Let's now go to Delegate Boyce.
Thank you, Mr. Chair. And the professor stole my thunder a little bit. I was going to bring up the issue of most times sheriffs do not come on the dates that they're going to be scheduled. And then what does the timeline look with that? But I say that all to say that between DC, Pennsylvania, Delaware, Virginia, West Virginia, New Jersey, Howard County, Baltimore City, and a host of other states that have anywhere from 3 days to 60 days. This is certainly something that is doable. And I would say that all these states wouldn't have this if there was an issue of tension or retaliation. And so the question for us is just what makes sense, and respectfully, not only to the sponsor, but to essentially this Todman case, what is the easiest path forward that fits into our current kind of rules and regs as it relates to the water restitution and eviction. And if we're saying
exactly correct.
You know, if we're saying that, so for instance, in Pennsylvania, they have a 10-day reclamation period from the postmark date of notice, but can request an additional storage for up to 30 days. And so that means that maybe the landlord there can probably put some storage in there. Virginia's 24 hours. And so I think we just have to figure out what works. So because the point is here, and I do want for us to be on notice about this, because I think people would have some issue. You know, you don't pay the rent. Unfortunately, it gets to the point where you are being evicted, and we can certainly all agree to that. But what we're saying here is that it doesn't have to be in a way that is inhumane. I think there's nothing like seeing baby clothes and toys on the side of the road. And to Baltimore City's point about having to spend, you know, $800,000 yearly to clean up roadside evictions. You know, so we're talking about a waste issue, right? An environmental issue, but a humane issue. You haven't paid the rent, we get it, but there's got to be a humane way where we can, quote unquote, put you out without putting out your stuff scattered all over the place. And so, again, all these states are doing it, and doing it pretty much well, between, again, 24 hours up to 60 days. We just have to figure out what path is very direct and doesn't cause complications, first and foremost, for the tenant and for the landlord. So I just wanted to put that out there.
Thank you, Delegate Boyce. Let's go to Delegate Healy, and then we're going to go to Sheriff Carr, and then we're going to go to Delegate Addison. Delegate Healy, you have the floor.
Okay, thank you. Yeah, I have a couple of more I think practical questions. I was listening to the sheriff. I got a couple of questions about the situation. I mean, the sheriff sees human nature, and in these situations already, when people are all fraught about these things. And I'm wondering about what in this bill or in this law is going to force the landlord to actually allow the tenant to reclaim the property within 10 days. Because, I mean, I can see, somebody who is just so ticked off at the tenant for not paying that they just, they don't answer the phone, or they set up a time and then they cancel, and then pretty much have, and there may be legitimate reasons, maybe not, but 10 days goes by and they never got an opportunity. Then what happens? That's one of my practical questions. And the other question I have is about what 10 days actually means. Are these calendar days? Do weekends count? Holidays? Or is it just business days? So
They're
I
typically
wanted to know
calendar
that
days.
too.
I'm sorry, they're typically business days. Ben, typically throughout these landlord-tenant timeframes, as I recall, those are business days, right?
I think it's calendar days, Chair Holmes.
Calendar days?
Yeah.
Okay, okay.
And just real quick, Chair Holmes, so they're in subsection E2, just to Chair Haley's or Delegate Haley's comments, during the 10-day period, the landlord has to make the tenant's personal property reasonably available, and then there is like a penalty provision if they're violating that, and that's outlined in H, that a tenant, if a court's finding in favor of a tenant based on a violation of this section, the tenant could be entitled to damages, that type of thing. So
Does that kind of answer at least half of the question, Delegate Healy?
It answers half of the question, but the other half is, yeah, it says they mustn't do it, but and I guess there is a penalty, but even saying, have they provided the reasonable or not, that can be disputed back and forth, I'm sure. I couldn't answer the phone. I had some other business in my life, and I wasn't able to get back to them in time. I just wonder about the practical side of how this is going to work.
Thank you, Delegate Healy. I appreciate that. Sheriff Carr, we'd like to have you offer some suggestions too, if you don't mind, Sheriff Carr.
No, thank you. And I think the delegates, thank you for just allowing me to speak, because you guys are really speaking a lot of the points and facts to this. To the point as far as what you would do if the property owner does not relinquish their property. Again, from my understanding and reading this, is basically saying that that person would have to go back to court and actually go and look at a civil option. That takes time. That means you now have all of my belongings up until what time that the court may actually hear this case. The second thing, going back to Delegate Stewart, I do agree with you. As sheriff, I am impartial, so I don't go with the tenant or the property owner. My job is to make sure I'm trying to be respectful and show empathy to everyone, but actually execute this order. I would say the actual notification of the day that we would come, one of the reasons why we, as far as law enforcement, have, at least I can say this locally, is that you have people, where are they going to go? This is their last option. We've had situations in which people barricaded themselves inside of their homes, knowing or being told by the property owner that, hey, the sheriff is coming. Now, they may be telling these tenants the sheriff is coming, one, to either try to get some sort of funds or relief or money before we get there, or two, you want this person to leave before we actually come. You just want to recover your property. We've seen people who become desperate in the fact that, hey, there are hard times. It's not like people are just going to be evicted or their property will be placed into a storage unit and you think these people will just move on. Some of these people have nothing else or no place else to actually go. The next thing is having the property owner just have that type of control over the tenant. We've seen where, and I'm not saying all property owners, but these property owners have actually used that to their advantage. This person owes me money. I now have some of this property. Who is to say that, hey, that's what I put in the storage is all we saw or all we have. I think when it comes to as far as law enforcement or public safety being there, as far as the exchange, we're already spread thin. And I can only tell you that, and that doesn't make a difference or what jurisdiction. This is more the lines where it goes to that domestic or that civil piece, to where we now have to be involved. And I just know where we are right now, not only as a jurisdiction, as a state, as a country. We're getting people who are becoming more emotional, and this is a very emotional case. Taking office, one of the suggestions that I started to do was I actually posted on our website, when we do get an eviction writ, I actually posted on our website, doesn't have the name, it has the actual address. So any individual can actually go on, if the property owner is telling them, hey, you're up for eviction, you're able to see that the sheriff's office actually has an eviction writ. So there are other options that we can explore in order to try to make sure that the tenant does not have to live in fear. Because again, this bill doesn't talk about what happens if the property owner basically tells the tenant and actually posts a notice saying the sheriff is coming. If it rains, it snows, it's below 32 degrees, we're not coming. What do they do then? You're going to have that person move out during that time frame because they don't know if we're going to be there or not. So there are many different ways. And I know Baltimore City, I think, is the model for this. But Prince George's County is #1 in the state. Last year alone, we had 28,000 eviction writs. Out of that 28,000, we only executed 4,000. So it tells you that we are trying to actually, work with our tenants and make sure that we are able to provide wraparound services. Also, we have in the courts legal representation for those tenants so that they could actually get some sort of resources before it actually gets to this point. I hope that we can actually be a little bit more proactive and provide resources before we have to get to the point to where the sheriff's office, myself, my team would actually have to come out and do evictions. And if so, I do believe that if we will make sure that it is definitely done in a respectful and we show empathy. I just some of the language, especially where we would make the determination if the property owner actually followed the guidelines as far as posting and provide us that and then file it with the courts. I think those are steps that, we're already behind in a process. So currently right now, we try to execute within 90 days of receiving the eviction writ, but we're a little bit outside of that. So depending on those jurisdictions, you will start to see even more of a lapse in those type of services.
Thank you, Sheriff.
Thank you.
I appreciate that. Delegate Addison, and then we're going to go to Delegate Stewart.
So, thank you. Ben answered one of my questions. It was the business days or calendar days, and the sheriff also answered one of my questions, which was the posting of the evictions. But I wanted to also ask, if a tenant has been evicted for non-payment, who is going to pay for the storage? Will it be the landlord, or will it be, because it can't be the tenant if they've been evicted? So I'm kind of confused on that.
Yeah, pull that section up in the bill, Ben, because the bill does have that language in there, Delegate Addison. Let's let Ben pull that up.
One second, trying to
Sure,
find.
take it.
Yeah.
And while you're pulling it up, ladies and gentlemen, what I would like for all of you to do is I would like all of you to send, and this is when I say all, I mean everyone that is here and present on this discussion, whether that is subcommittee members or guests. Anyone that has suggestions based upon our discussion, I would like for you all to send those to me individually or jointly with someone else to my office or to Ben, or to my office and Ben jointly, so that we can begin to compile all of these suggestions so that we can go through them and begin to make sure that next week we have a voting scenario on the discussion for this week. I hope I'm clear on that. Please send us your suggestions based upon this discussion, and please do that urgently. Ben, have you found that section yet?
Not yet, Chair Holmes.
Okay, let's go to Delegate Stewart and wait for you to come back to Delegate Addison's question.
Yeah, I mean, just to answer, I can answer Delegate Addison's questions real fast, which is that there's no cost recovery in this draft of the bill. The landlords would be responsible for paying for the storage fee. To Delegate Naraki's point that he made earlier, he's totally right that Pennsylvania and West Virginia, who have the 30-day reclamation periods, yeah, and there's the language right there, lines 13 through 15. But he's right that Pennsylvania and West Virginia do require the tenant to pay for the storage, which obviously makes that longer 30-day reclamation period more palatable to the landlords because they're not on the hook for it. That said, I still don't think that that's an awesome regime because the landlord probably has to go back to court to ask for the payment to do that. And that could be difficult, you know, and it's just more attorney's fees. So I think the more straightforward way to do this is just to go with, you know, the route that a few other states near us do, which is the shorter period, you know, less than a month. But with this provision here about the cost recovery, I think is the more straightforward way to do that. To answer a couple of other questions that came up, first of all, I think Delegate Healy asked if the tenant doesn't pick stuff up after 10 days, what happens? The answer is that it's abandoned and that the landlord can throw their stuff away after the reclamation period is over. But the crucial part of this, if you read the Todman decision, is the Judge Wilkinson, who wrote the opinion for the panel on the three judge panel on the Fourth Circuit, he was especially livid about the lack of notice of abandonment. That was one of the real key points the judge made, was that you can't just treat people's property as abandoned without the due process angle of letting them know that their property is going to be abandoned. And so so that's why, you know, that notice is so crucial. And to the notice point, I think one amendment I might propose to Ben and to you, Mr. Chairman, is to add electronic notice to the notice. Right now we have mail and nail. We have both mail, certificate mail. So you get a certificate. So that's your proof. I think a few other people mentioned, you know, what happens if somehow the notice is defective. It's true that there are civil remedies, including attorney's fees in the bill. And I think those will provide a really good deterrent for most landlords to try to circumvent the provisions of the law, because otherwise they can get sued and face pretty significant civil liability. But I do think the types of notice is important. So what I would recommend is, you know, definitely get that certificate mail, because then that means it's not certified mail, it's certificate mail. So the landlord would have the certificate showing they didn't mail it, and they could show that to the sheriff or show that to a future judge if there was ever a lawsuit. I do think we should probably go with some kind of mailbox rule, especially if we lower that amount from 14 days. I think we should go with some sort of mailbox rule to make sure that we add enough time for the mail to actually get there. Number two, I think the photograph of the nailing on the door is excellent, but obviously in some cases notices get taken down. And so it, you know, or you know, sometimes landlords could, you know, they can nail it, take a photo, and then take it down. So I think that a third form of notice, that being electronic, if the landlord does have the phone number or the email address of the tenant and could either text or send an email, I think that's good for two reasons. One, we live in the 21st century, and that's just the most like how people mostly get information is through their email or through their text. But number two, it's also much more objective, verifiable proof, because you can take screenshots and it's way easier to both prove to the sheriff and prove to a future court, if you ever went down that road, that the notice was given, because you're going to have records of the text messages and records of the email addresses. And I think that's, oh, and then the only other point I was going to make is, in terms of, you know, Sheriff Carr is concerned about how overworked they are. I'm very sympathetic. What I'll note though is that several jurisdictions, including Prince George's, I believe in their local eviction laws, basically make the sheriff stand there throughout the entire process of the eviction, while the movers that the landlord hired in some cases basically removes the belongings and then put them on the street. Under this bill, the sheriff would really only just need to be there to watch for the locks being changed and then leave. So to the point of like sheriff workload, this bill actually would make the process shorter and simpler for sheriff's offices across the state, is my understanding. Now, Sheriff Carr looks like he's raising his hand, so maybe I misstated that. If I misstated that, I'm sorry, but I think that's my understanding of what the bill would do.
All right, thank you. Let's do this. Let me go to Delegate Healy, then Delegate Naraki, and if Sheriff Carr wanted to add something, we'll go to Sheriff Carr after that. Delegate Naraki, you have the floor. I thought I saw Delegate Healy, but I see.
Sorry.
Oh,
Sorry.
I did have my name up.
Okay, there you are. Now you're back. Yeah, go ahead.
It
Delegate
just went
Healy,
off by itself.
Go ahead. Delegate Healy,
Yes.
go ahead.
Oh, you want me to go first?
Yeah, go ahead. Go ahead.
Oh, okay. I just, my only suggestion, I mean, I've listened to all of this. This is a very thorny situation. And, but we have heard that it's working successfully in other states. So my suggestion is that, we look for the state where it works the best and copy what they do and not try to invent something here. That's my just, because I'm not sure we're going to figure this out. That's
Thank
all.
you.
Thank you.
Delegate Naraki?
Thank you, Mr. Chair. I appreciate it. I'm just kind of I was looking through the Todman case here, and I'm on page 21, Delegate Stewart, if you're going to go look at it. I just want to let you know where I'm at, so you know where I'm at inside of it. But I'm looking at what the judge says, and the judge says here that the reclamation period, he would have been comfortable with a reclamation period even as short as a few hours. So I'm curious, you know, why we're at 10 days if a judge is saying that a few hour reclamation period would be okay. I'm just kind of I'm not understanding where kind of 10 days is coming from if the judge is saying even a few hours would be okay.
A few hours if you're right there and can reclaim your stuff and put it on a truck and go, I would say. But if you don't, I'm sorry.
Madam Vice Chair, this is what the judge said. The judge says, had the abandonment ordinance provided for any reclamation period at all, even as short as a few hours, they would have been able to retrieve their belongings. So I'm just reading what the decision said there.
All right. All right. Delegate Stewart?
Yeah, just very briefly. I actually read this section already because this page and this quote came up, I think, in MMHA's testimony during the hearing. So I'm already familiar with this quote, and I reread it. I would disagree with Delegate Naraki's characterization of what Judge Wilkinson was saying here. He was saying that the facts specific to the Todmans, if they would have been given a few hours, they would have been able to reclaim their property because they were like right there and they would have been able to get to it. And they didn't need a moving van or anything for it. So in their specific case, they would have gotten their property back if the reclamation period had been short. But what Judge Wilkins is saying is not that a few hours notice or a few hour reclamation period passes constitutional muster. He's making kind of a little bit of a proverbial kind of argument, like judges like to do, saying like, oh, even if you could have given a couple hours, that would have been good enough for the Todmans. But he's not saying that a few hours reclamation period would have been good enough for the Constitution. He definitely does not say that. And if you go on to the crux of his analysis about the reclamation period and sort of like listen to his fervor about it, I think it's pretty obvious that a few hours is not good enough. And I think that what made us vulnerable here is that Maryland is such an outlier. We don't provide any notice whatsoever. And so I think to Delegate Healy's point, there's safety in numbers, right? And so I think that if we're going to try to escape basically the constitutional bad zone here, we should just latch on to some other notice provision in another state because that hasn't been struck down, that hasn't been struck down. So I think as long as we are meeting one of our neighbors or doing better than them or providing more notice than one of our neighbors, then I think we're safe. But if we try to go in there and say the notice period just needed to be 48 hours, I think we're asking for Judge Wilkinson to come back, in the next lawsuit and hammer us again. And just in case people are not as intimately familiar with the ideological bent of the Fourth Circuit judges as I am, Judge Wilkinson is the most conservative judge on the Fourth Circuit. This was not like some sort of like Obama, like liberal appointee who's like going off on how, great tenants' rights are. This is the most conservative judge they've got, completely lambasting Baltimore City and Maryland for doing this all wrong. So anyway, that's but very briefly, in short, I think Delegate Naraki's characterization is a little bit off. I don't think that's exactly what the judge was saying, but I would certainly invite all the members to read the opinion for themselves and make draw their own conclusions because it is a very, very interesting opinion.
Thank you very much. Now I'm going to close this out, and in me closing this out, what I'm going to do is give Sheriff Carr an opportunity to have a brief statement. And I saw Arthur Turner's hand up a couple of times. I'm going to allow Arthur Turner to have a brief statement, and then we're going to close this out till next week. Sheriff Carr, you have the floor.
No, thank you. I just want to be brief. I do want to talk about as far as the time frame, and thank you, Delegate Stewart, for pointing that out. Yes, we do stand there, and we do make sure that all items are presently out, and we look at the condition to make sure everything. Also, we look between for illegal substance, firearms, anything that we know that then can lead to something else. So, I mean, there are reasons why we actually stand there. I guess our biggest concern is that we never want to have to come back to a situation. So again, we've always placed everything out. I know Baltimore City has placed or kept everything in, so I really can't speak to it. But I just know just from what we've dealt with face to face that it has been an issue, and the reason why we've been there, we've actually made arrests because it's on both ends. So I know you guys have a huge task to try to figure out exactly how we can try to make sure that we serve our citizens. But from the law enforcement standpoint, this is something very difficult, and I know the process in which we have right now maybe needs some tweaking. But I know if keeping those properties inside of keeping the property of the tenant inside of the home, I just think is going to be a huge mistake, and law enforcement is really going to have to deal with this on the back end as far as responding to some of these calls for service.
Thank you, Sheriff Carr. Mr. Turner, you have the floor briefly before we close out.
Thank you, Chair. I just wanted to add specifically about some of the notice provisions in the state of Maryland. Baltimore City does give 14-day notice of the eviction. Howard County, Anne Arundel County, they give notice of the eviction dates to their tenants. However, some other jurisdictions, they only give ranges of when the eviction is going to happen. Montgomery County, I believe, Prince George's County, they don't give the exact date of the eviction. In addition to being a violation of time, and we believe that actually giving notice of the eviction date to these tenants will actually encourage them to move faster because they know exactly when the eviction date is so they can plan accordingly. If we remember Todman, they were under the notion that the eviction was going to happen at a certain time, and the eviction did not. Under some of the jurisdictions, in addition to Baltimore City, where there's abandonment provision, Baltimore County, Prince George's County, Anne Arundel, or I shouldn't say Anne Arundel County, a number of counties do have abandonment provisions as well, which I think opens those jurisdictions up to Todman violations directly, in addition to the rest of the state. And I thank you for the time.
Thank you, Mr. Turner. All right, ladies and gentlemen, we're going to close this out, and I want to emphasize again, please send us your suggestions on this particular piece of legislation. We've had a lot of discussion here. Next week, I want to have us to have this thing all tied up in a nice little neat bow. And so we can make a vote on the amendments, and we can get this out of HRP and onto the full committee. Ladies and gentlemen, I appreciate your time, and I apologize for the lateness in getting started, but tis that time of year again, ladies and gentlemen. Thank you all for joining us, and we'll see you soon. The meeting is now adjourned.
Thank you.